When a resident enters a nursing home, assisted living facility, or other long term care facility, the facility often has an admission agreement that needs to be signed. The admission agreements are often long and complicated, and people sometimes sign them without reading through them or understanding what they say. Sometimes facilities even pressure other family members, like the resident's spouse or child, to sign admission agreements. And that can be a problem because these admission agreements often contain legal provisions that deeply affect your rights. For example, one provision that we often see in admission agreements is that someone is signing as responsible party. Responsible party means different things in different contexts, but it can mean that the person is agreeing to pay the bills of the resident, which might be $10,000 per month or more. If you sign an admission agreement for a family member, you might be taking on a huge liability without even realizing it. Another provision that we see sometimes is that the resident has to list their financial assets in the admission agreement and agree to spend those assets on care at the facility. This is a problem because if you want to do any kind of asset protection planning or Medicaid planning and try to preserve your savings for other family members, it can be much harder to do that if you already agreed to spend all your savings on care at the facility. For all of these reasons, we always recommend that before you or a loved one signs any kind of admission agreement, you have it reviewed by an elder law attorney who's familiar with these kinds of agreements and facility issues. And if you're in New Jersey, we're happy to do that for you.